Minister, Chief Justice, members of Parliament, eminent jurists, journalists, members of the Jethmalani family, ladies and gentlemen. Let me as well begin with my tribute to the person whose memory we today mark. I'll share with you two early encounters. The first was when I was in class 8 in 1975, and my father suggested that I visit the Bombay High Court to hear Ram Jethmalani in a critical case for preserving our liberties. This was 1975, late 75. It was during the emergency, and the case was titled N.P. Nathwani versus the Commissioner of Police. It was my first visit to the Bombay High Court and to the Chief Justice's Court, and the bench comprised Chief Justice Kantawala and Justice Tulsapurkar, who later on, of course, came to the Supreme Court of India. The judgment is reported in volume 78 of the Bombay Law Reporter at page 1, and it records the appearances N.A. Palkhiwala with R. Jethmalani, K.S. Cooper, A.B. Divan, S.J. Sorabji, and 153 other advocates as per the list handed over by Gagrat and Company. The Commissioner of Police had refused permission to a group of lawyers to hold a private meeting to discuss the preservation and promotion of civil liberties and the rule of law. The bench unanimously, there are two judgments, one by the Chief Justice, one by Justice Tulsapurkar. They preserved the ancient right of assembly and quashed the police commissioner's prohibitory order, which prevented the lawyers, or which had prevented the lawyers from convening the meeting. Ram's advocacy was stirring. If my math is correct, he was 52 at that time, but his presence and his powerful advocacy transformed the court into a theater. It was a mesmerizing experience for a schoolboy and an early lesson on the indispensable role of lawyers and judges in preserving liberty. The last paragraph of the law report sort of piqued my interest, so I'll read it to you. It goes this way. It says, Mr. Sorabji on behalf, and this is what Mr. Gurumurthy had also mentioned. Mr. Sorabji on behalf of the petitioners stated that counsel and attorneys appearing for the petitioners are not charging any fees and will be only pressing an order of costs restricted to the mere out-of-pocket expenses incurred, of which a statement is handed over. In view of this statement, the respondents are directed to pay the petitioners a sum of rupees 3,742 and 51 naya paise, being the out-of-pocket expenses incurred by the petitioners. So it was a small triumph at a very dark time in our history, no doubt made sweeter by the 3,742.51 rupees which the police commissioner was required to pay. My second early recollection, was in the year 1977. So we are 2 years on. And by then, Ram had left India. He'd left India in 76 during the emergency and had returned to contest the Lok Sabha elections. He ran against the serving law minister, H.R. Gokhale, in the Bombay Northwest constituency. And I remember attending a meeting at Marine Lines in Mumbai. There was a hall where the opposition candidates were all on the stage, but not Ram. Where was Ram Jethmalani? Midway through the meeting, there was a slight commotion, and in strode Ram to great cheers and applause. I remember him walking onto the stage, apologizing for being late, and heading straight to that Chicago radio microphone. And then he declared, "The Hun is on the run." The audience was stunned. What was Ram Jethmalani talking about? And then he went on to say that the Prime Minister's intelligence agencies had projected a very bleak prospect for her and that she was set to flee the country. That is why the Hun is on the run. These encounters distilled for me some of Ram Jethmalani's great qualities: courage, an unflinching focus on freedom, an actor's way with words, and fearlessness for the cause of the client. Let me move on now to basic structure. And frankly, I thought that by now, as the last speaker, this ground would have been covered. But let me just share with you a little nugget. The notion of basic structure, which has been explained by the speakers ahead of me, actually started with a German professor, Dieter Conrad. And he delivered a lecture at Banaras Hindu University where he propounded a theory that some things in the Constitution are immutable or are unchangeable. And barrister M.K. Nambiar, who argued Golaknath, found out about the Conrad lecture through his friend T.S. Ramarao, a law professor at the Madras University. So this is how it was run initially in Golaknath, and then of course Palkhiwala took it to a whole new level insofar as the Kesavananda Bharti case is concerned. Let me just indicate a couple of factors as I understand them in terms of context, because I think political context is very important to understand and justify the basic structure doctrine and why it's so important for us here in India. So it was mentioned that there was the popular government had pushed through and made efforts at a large number of laws which sought land reforms, privy purse was mentioned, bank nationalization, taking over of other land and assets was mentioned, and therefore a clear attack, not just at Part 3, which is fundamental rights, but also a constant testing of the bounds of judicial review. What can be done? How far can the courts go? How far should the courts go? And allied to this searching interrogation on the limits of law in terms of judicial review is another aspect of our constitutional model. And that really is what I think Mr. Nariman mentioned, that our constitution has been amended 105 times in 73 years. 105 times in 73 years. Now contrast that with the United States Constitution, which has been amended 27 times in 234 years. Or consider the Japanese Constitution, which hasn't been amended even once since 1946. In Australia, in 121 years, it has been amended just 8 times. So what you have is that, we have a great regard for our Constitution. We have a great regard for constitutional sanction. And a result of that is that we have certain provisions which I suspect don't make their way into many other constitutions. For example, just ahead of a chapter which is, loftily titled Relations Between Union and States, very important, Part 11 of the Constitution, or the Scheduled and Tribal Areas, which is Part 10 of the Constitution, is a whole chapter in our Constitution beginning with Article 243ZH, and it is titled Cooperative Societies. Now, I can scarce imagine that there would be parts, that there'd be too many constitutions anywhere in the world which has cooperative societies right up there in your basic and foundational document. But we have it. And so there are several parts which, of course, can be removed, which can be amended, which can be altered. But then there are others, I suspect, Part 3, for example, with some exceptions, which must hold out if we are to preserve our democracy. So Article 368, which was also referred to, is the great constitutional provision by which the Constitution itself comes to be amended from time to time. And here I'd like to borrow Nani Palkhiwala's phrase, deface and defile. And what he says is, and what he writes is, that does the constitutional amendment, the question or the test is, does the constitutional amendment deface and defile our great charter beyond recognition with respect to any of its essential traits? Palkhiwala ends his 1974 book, Our Constitution Defaced and Defiled, with a caution. The amending power under Article 368 is not a death wish or a provision for legal suicide. To quote him, the nation may pass through times like the present when it suffers a loss of identity, but never the Constitution. The founders had an unshakable faith that however stormy the days, the preservation of the identity of the Constitution will always enable the nation to come back into its own. And so the basic structure doctrine is really about protecting the essential identity of the Constitution. Very briefly, I think many of these doctrines in law are tested or are valid depending on their utility. I believe it's been of tremendous utility for us here in India in preserving crucial aspects of the Constitution, such as, for example, the scope of judicial review and the power of the court, or reserving to the court or our higher judiciary the power to strike down legislation which otherwise falls foul of constitutional provisions, and a few other areas also where the basic structure doctrine has been applied to preserve liberties, to ensure that our democracy remains intact and doesn't suffer too many inroads in terms of rule of law. And as Mr. Nariman mentioned, this doctrine has found resonance beyond our shores. So we have the doctrine applied to strike down constitutional amendments in Bangladesh, in Belize, as was mentioned by Mr. Nariman as well, where the 8th constitutional amendment of 2011 was struck down because it was found to make too much of an ingress in terms of destroying property rights. Kenya has used and employed the doctrine for striking down one of their constitutional bills. Uganda as well, Malaysia as well, after a little bit of back and forth, and Pakistan has adopted this particular doctrine. Singapore found that the basic structure doctrine is not really aligned to their constitutional form, their history, and so they rejected it. I had the advantage of access to a manuscript which my father maintained during the Kesavananda Bharti case. So as was told to you, there were 13, it was the biggest and strongest panel in our Supreme Court, 13 learned judges. Nani Palkhiwala was leading the charge on behalf of the petitioners. There was H.M. Sirvai, who was leading the defense of the constitutional amendments on behalf of the states. And this is what my father penned on Thursday, December the 21st, 1972. From his manuscript, 30th hearing, 3:40 p.m. Nani Palkhiwala. In another 20 minutes, I will have done. I will end as I began on the question of approach with a few well-chosen and well-phrased words of a distinguished lawyer. I would, however, request your lordships not to read the name of the author. Palkhiwala given cyclostyle bunch, which he hands over to the court master. I again request your lordships not to read the name, because if you do, you will not believe your eyes. The name is H.M. Sirvai. Laughter. 3 interruptions by Sirvai. Sirvai. Articles written, Member of Parliament in the Select Committee told me that certain clauses were dropped because of my articles. Nani Palkhiwala. Thank you. Sirvai. I will fully explain the articles. Nani Palkhiwala. You will do so at length when your turn comes. Justice Hegde shows that judges and lawyers should not write articles. Justice Chandrachud, Y.V. Chandrachud, Mr. Palkhiwala, have you not committed a breach of copyright? Laughter. The punch in Palkhiwala's closing submissions is revealed on a reading of Sirvai's passionate defense of the right to property in a series of 3 articles that had appeared in the Times of India 17 years before Kesavananda Bharti was argued. So let me end with some words from Jethmalani, Ram Jethmalani, on Nani Palkhiwala. And when Palkhiwala passed in June 2004, this is what Mr. Jethmalani had to say. I believe that Nani's greatest contribution in the field of constitutional law was his glorious success in the Kesavananda Bharti case. Nani had realized that the Constitution had been treated with even less respect than is due to the Cattle Trespass Act. He brought in his complete legal expertise and repertoire to sustain a unique proposition. Whatever be the width of the amending power of the Constitution, you cannot, by any kind of majority vote, alter or destroy its basic structure and framework. The government of the day made an inglorious attempt to have Kesavananda judgment reviewed and reversed. Fortunately, the judges did not accept the invitation. The doctrine is now an incontrovertible part of our constitutional jurisprudence, and India is spared the danger of demise of its democracy. The judgments of our court and the judgments of the overseas courts which have upheld basic structure use expressions like pillars, supports. These are the great supports and the pillars of our constitutional edifice. But to end, let us also remember that in addition to the pillars and the supports, we need spaces. We need spaces for our citizens. We need spaces for the citizenry speaking through civil society. We cannot possibly afford a situation where there is no space for a comedian, there is no space for a journalist, there's no space for a cartoonist, there's no space for an academic. So the defense of democracy, assured, at least for a while, by this important utilitarian principle of basic structure, also requires each one of us, like the very eminent lawyers mentioned in the past, to ensure that the spaces do not shrink any further. I thank you very much, and I thank Mahesh for this. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.